Sorry,
Sure.
one other question. Some lower courts have taken the view that even if you have a discrimination against religion, so you failed the Smith test, that you still have to show a burden, a substantial burden in addition to that. And one might read a footnote in the Fourth Circuit's opinion to suggest that. Do you have thoughts about that?
This court has held in cases, certainly most recently in the Lutheran Trinity, that discrimination on the basis of religion, if you are treating people of faith worse or a particular religion worse or discriminating in the Lukumi sense, that triggers strict scrutiny.
Thank you.
Justice Kavanaugh.
Just to be clear, your position in this case is that you're not seeking to alter the instruction in the classroom or what's the content of the classroom. You're only seeking not for these children to be forced to remain in the classroom, correct?
Exactly.
And then if there is a substantial burden, you get to the next step of the analysis. Why do you think this is not generally applicable?
Two sets of reasons. One is that it's discretionary. So by definition, it's not generally applicable. The board can turn on a dime and change who gets exemptions, what kinds of exemptions are covered. And that's in fact the record here, that they changed overnight as to what kinds of exemptions they would allow. And two, in terms of lack of general applicability, is the patchwork of exemptions they currently allow. They allow exemptions for musical performances. I think they allow exemptions for dissection. They allow exemptions for Halloween, for birthdays, for any kind of religious observances on Saturdays or Sundays that might interfere with extracurriculars. The one thing they allow exemptions for sexual education in the classroom components. The one thing they don't allow is the exemptions for the storybooks. And that is sort of the hallmark of something that is not a generally applicable policy.